Good afternoon. Welcome to the House Judiciary Committee. It is March the 6th, 2025. Thank you all. If people could come to the table. We're going to get started here. Ladies and gentlemen, we have a hard stop at 4 o'clock today, a very hard stop at 4 o'clock. So we're going to do the best we can to get through as many bills as we can. House Bill 1423, Delegate Crutchfield and panel, go right ahead.
Good afternoon, Judiciary Committee, Mr. Chair, Ms. Vice Chair. For the record, I'm Delegate Charlotte Crutchfield. I represent District 19 in Montgomery County, and I am here to testify on behalf of HB 1423, which is to establish a commission to review and assess racial disparities in the state criminal justice system. HB 1423 seeks to establish a commission to examine racial disparities in the state's criminal justice system and to recommend policy solutions to address the disparate treatment of African Americans, Hispanics, and other non-whites. Maryland's correctional facilities currently exhibit stark racial disparities in their inmate demographics. Although Black Marylanders comprise approximately 30% of the state's population, they account for 71% of those incarcerated in Maryland. In fact, Maryland has the nation's highest percentage of Black people in the prisons when compared to the general population. Comprehensive data and analysis of those disparities are essential to effectively addressing the harmful consequences of mass incarceration, which has devastated communities and profoundly impacted individuals and families. The commission will examine these disparities at every stage of the criminal justice system, from policing to prosecution and sentencing. It will also study potential reforms, including modifications to the possible abolition of the state's felony murder doctrine in cases where individuals had no clear intent to commit murder. This legislation follows a key recommendation from the Maryland Equitable Justice Initiative, which proposed 18 policy changes to address longstanding issues, contributing to racial disparities and high incarceration rates. It is with all this in mind that I have a wonderful panel to discuss further and to hopefully convince you of how important this legislation is. So I am looking for a favorable report from this committee. Thank you very much.
Mr. Chairman, I see folks are taking pictures. Please take the pictures because this is a rare sight. The public defender and the attorney general at the same table in a room, and that speaks volumes. I want to thank the committee. I want to thank Delegate Crutchfield for her leadership. House Bill 1423 is a critical step in addressing racial disparities in our justice system. It establishes a commission to examine these disparities at every stage, from arrest to parole, and identify solutions. Maryland Equitable Justice Collaborative, which I co-chair with the public defender, strongly supports this bill. Our collaborative spent the past year studying racial disparities in mass incarceration. We listened to the voices of many, including academics, impacted individuals, advocates, and experts. And in December, the collaborative approved 18 recommendations to reduce mass incarceration, including a call for comprehensive research into racial and geographic disparities in Maryland prisons. So House Bill 1423 advances this effort by creating a dedicated commission for this critical analysis. The need is clear. As you heard, Black Marylanders, we make up 30% of Maryland's population, and we represent 71% of the prison population. And Black men are overwhelmingly represented in our prisons. It's a disgrace to Maryland. It's the worst data set in the nation, and we've got to do something about it. No other state comes close to this racial disparity. House Bill 1423 ensures Maryland takes a data-driven approach to addressing these disparities through research, policy analysis, legislative recommendations, and reform oversight. The commission's work will examine key policy areas, including mandatory minimum sentences, bias and risk assessments, and effective alternatives to incarceration. One of the questions you're going to ask is, if you're doing the Maryland Equitable Justice Collaborative, why do we need this commission? And I'll be more than happy to answer that question when you ask that of me, because, Mr. Chairman, my time is up, and I'm going to yield back the balance of my time.
Good afternoon, Chair, Vice Chair, distinguished committee members. I'm Natasha Dartig, Public Defender and co-chair of MEJC. We are here in support of HB 1423. Thank you, Delegate Crutchfield, for sponsoring. There is urgency in addressing the racial disparities in Maryland's criminal legal system. The disproportionate target of Black individuals at every stage, from arrest to sentencing and reentry, leads to lifelong consequences. This is essentially why MEJC was born. Data from MEJC research and work shows bail disparities. Black people are more likely to be denied bail or assigned a higher bail compared to white people. Charging disparities. Black children make up nearly 80% of those tried as adults, despite being only 1/3 of Maryland's youth population. Sentencing disparities. Black defendants receive higher punishments even for similar offenses. The role of the commission in compiling data and comprehensively analyzing root causes of these disparities is critical to defining solutions. The commission will examine the impact of mandatory minimum sentencing, which is crucial to studying how mandatory minimums do not improve public safety, examine the use of risk and needs assessments, tools which historically reflect racial biases due to flawed algorithms, and explore racial neutral assessment models to ensure fair evaluation at every stage. The commission will evaluate evidence-based programs that reduce recidivism, provide mental health and substance abuse treatment, increase public safety, and save taxpayer money. We must invest in solutions that work and not perpetuate cycles of incarceration. We must be guided by data and take into account real-world experiences. HB 1423 is an essential first step to breaking the cycle of racial disparity in Maryland. I urge a favorable report. Thank you.
Questions for the panel? Delegate Sample Hughes.
Thank you, Delegate Crutchfield, for the bill, and thank you to your great advisors there at the table with you. Just the other day, we heard a bill that really spoke about the isolation issues in the Corrections Department of Corrections. And I was just curious, and I'm sure that has some disparities as well. I was curious if this commission could delve even a little deeper into that, because we're talking about, you know, how I think the mother was at the table, was talking about her son not having proper utility or toiletries items, and just the list goes on and on. And I was just curious if that might be also a part of this commission. Thank you, Mr. Chair.
Yes, and that would be, definitely, because this is going to dive into the criminal justice system here in Maryland. But the other thing to also think about, that particular person could also file a complaint with the ombudsman for Maryland as well, for, you know, criminal justice issues.
Okay, thank you.
Delegate Taylor.
Thank you, Mr. Chair. Mr. Attorney General, why do we need this commission if we already have the MEJC?
I'm glad you asked. As I mentioned, I mean, this does build, I think, on the work of the Maryland Equitable Justice Collaborative. I've sat where you sit now. I spent 8 years in the legislature, 4 in this committee, 4 in economic matters. There is nothing that compares to the imprimatur of the legislature. When you pass legislation that establishes a commission, that assigns the stakeholders, the experts, the impacted persons to those committees, and assigns staff to study this, you come back with, you're asking for reports with actionable recommendations where the presumption is the legislature will act on it. There's nothing that beats that. So we put out 18 recommendations. A number of them require legislation. I think 4 or 5, and perhaps the public defender or others who are in the audience who are on the collaborative correct me, about 4 or 5 of our recommendations are the subject of legislation before the General Assembly. We're optimistic on some of them, but this commission will come back with actionable items and has an oversight component in it. So while the work of the collaborative is important, it's ongoing. And what the public defender and I failed to mention is we're asking for a friendly amendment that both the public defender and the attorney general are amended into the commission. A friendly oversight, I think.
In fact, my apologies because that amendment is in place. Yes, that is a friendly amendment that has been accepted.
So I hope that answered your question.
It has, thank you.
Delegate Simmons?
Thank you, Mr. Chair. Thank you, Mr. Chair, and welcome. One of the biggest things when we think about our criminal justice system and the courts is about sentencing guidelines. We all focus on that as well. And can you talk a little bit about how that adversely impacts the minority community?
Would you like to?
You can take it. I'm going to defer to the public defender and the sponsor.
So when we speak about sentencing disparities, we're speaking in terms of what we've seen. The data has shown that Black defendants versus, for example, white defendants for similar offenses, Black defendants are receiving harsher punishments. Through the work of the commission, by analyzing the data, we hope to dig deeper and to determine as to why that is, and in providing the data and the analysis, would be able to come together with solutions to that extremely urgent problem.
Thank you.
Delegate Pasteur?
Thank you, Mr. Chair. The findings of this is, if this passes, what is the impact? Because we do know it has impact, and we, not just in terms of what you want to do now, but in terms of a number of the other bills that we have out. My second look, whether it's about expungement, whatever. What is it? How does it change the paradigm? Will it change the rhetoric that we use very often when we have to present our bills to the public?
Well, you know, I thought about that. And one reason why I mentioned in my testimony the felony murder doctrine, because I hope it will provide the data necessary in order for us to move forward as we should, to indicate and really actually show what is happening in our criminal justice system, why there are so many young Black men, and I'm going to say young, quote unquote, that are in our system. I think this is what it will do. It will take the data to back up and to show what we need to do next.
And if I may, and I'm sure I may, will it not change the approach that we all take when we present our cases? Because often we speak first about the race component versus real criminal justice issues that we see in other states where they don't have that racial issue in the middle and they can just deal with the bottom line. Will that have an impact on that, how we present and our reality?
Well, Delegate, I think it's going to depend on how you want to present, okay? Because I would want to present the entire picture, okay? And that's what this will help to really create and to focus in on. So we really have the raw data. We have all the information. We know what is happening now, but let's back that up to really show what we need to do.
What the real issues
Yes,
are.
absolutely.
Yes, thank you, and thank you for this bill. Thank you, Mr. Chair. Thank you, Mr. Chair.
Thank you. Any further questions for this panel? Seeing none, thank you all very much.
Thank you.
We'll go now to virtually Ryan King, okay, Stephen Gravatt, Samaria Taylor, Philip Karoon. Mr. King is already on the screen, and we will take him this time first for 2 minutes, please. Mr. King, go ahead.
Sure. Thank you so much, members of the Judiciary Committee, for the opportunity to testify in support of HB 1423. My name is Ryan King. I'm here as the Director of Research and Policy with the Justice Policy Institute and the author of Rethinking Approaches to Over-Incarceration of Black Young Adults in Maryland, a 2019 report that highlighted Maryland's status as the worst in the nation for racial disparities in incarceration. I'm also here as a proud Maryland and Montgomery County resident. As has been mentioned at the time of that report, Black individuals represented 70% of Maryland's prison population, more than double their proportion in the state's overall population, which is slightly less than 1/3. That was 6 years ago. Today, the situation has worsened. Up to about 72% of those incarcerated in Maryland are Black, and among those serving long prison terms, often sentenced as young adults, which is between 18 and 25, that figure rises to 80%, the highest in the nation. These disparities are not coincidental. Maryland has constructed a legal system that systematically over-polices, over-prosecutes, and over-incarcerates Black individuals, particularly emerging adults. It begins with aggressive policing, where Black Marylanders are disproportionately stopped, searched, and arrested. It continues with a court system that subjects them to harsher charging decisions, longer sentences, and restrictive parole policies that limit opportunities for release. And ultimately, it results in lifelong consequences that disrupt families and entire communities, perpetuating the cycles of disadvantage that extend far beyond prison walls. In 2024, we expanded our research with the Right Investment 2.0, an interactive report that underscores how Baltimore neighborhoods most impacted by the criminal legal system are also among the city's most disadvantaged concerning employment, education, health, and housing. This ongoing disinvestment, especially in Black communities, has reinforced cycles of incarceration and socioeconomic instability. This HB 1423 is a critical step forward. We cannot address what we refuse to measure. This bill seeks to establish a commission to evaluate the cumulative impact of racial disparities in policing, charging, pretrial detention, sentencing, and parole, and the commission will provide lawmakers with the essential data and policy recommendations needed to confront systemic issues and inequities. And I urge you to support this bill and ensure its swift passage. And my last 7 seconds here, I'm here to answer questions, and particularly would love if anybody wants to talk more about why I think this commission is so important. I'd be happy to answer.
Okay. Good afternoon, Chairman and members of the House Judiciary Committee. My name is Samaria Taylor. I am an intern with the Justice Policy Institute, testifying in strong support of House Bill 1423. I'm a student from the University of Texas, and most of what I've worked on and studied is related to the criminal justice system and its specific relationship with the Black community. Because I'm from Texas and interested in the ails of the criminal legal system, I've closely understood and observed this system in Texas, as well as reform efforts. Although Texas is so far behind when it comes to any sort of positive reform, I think that we'll not see any sort of impactful reform unless historic disparities are addressed. This is why I'm so supportive of the passage of this bill. From what I know about the criminal legal system in Maryland, which is also true in Texas and most other parts of this country, Black people are overrepresented in all strands of the system, from traffic stops to long prison sentences. This disparity goes beyond just data, but impacts an overwhelming majority of the lives of the Black community. This system has never been just nor fair. In the conversation of reforming the criminal legal system, we must also address the root causes of inequity that lead to the current disparities in the criminal justice system. It is necessary to study the statistical biases in order to gear impactful changes. Without the analysis from the commission put forward by this bill, we would have colorblind policies which have never served the benefit of minority groups. Colorblind policies are what have created the high maternal mortality rate in Black women and the increasing rate of undiagnosed illnesses in all people of color. These types of policies do not work. We must steer change towards the groups that are most impacted, and studying racial disparities in the criminal justice system is paramount to advancing the notion of justice. As we have seen throughout history, many of the impactful policies that have happened on a national level began as a statewide policy. I believe that the passage of this bill into state law in Maryland will set a precedent for the type of criminal justice reform we need in this country. I urge the House Judiciary Committee to support this vital legislation and ensure its prompt passage. Thank you.
Mr. Chairman, delegates, thank you for hearing us today. I'm Phil Karoom, speaking for Major, not for the court system. Since the other witnesses have already said a great deal about the disparities, I wanted to jump ahead and respond to Delegate Simmons' question about the Sentencing Guidelines Commission. There's written testimony from the commission that is in your files today. One of the eye-catching facts in that is that in Maryland, the median overall non-suspended sentence for Black citizens is double that for white citizens. Mr. Justice White of the U.S. Supreme Court once said that the plea bargaining system is not part of the criminal justice system. It is the criminal justice system because 95% of our cases are resolved through plea agreements. So this is one crucial part of what a Racial Disparities Commission needs to study. There are other states that have begun this study. In Massachusetts, Harvard Law School has begun a study that is changing the system there. In Wisconsin, their universities have begun such a study. they found it 74% more likely in Wisconsin that black defendants receive a plea agreement that involves incarceration as opposed to whites. So it also leads me to point out in the testimony of the Sentencing Commission that you'll find in your files, they have recommended that there be a substitution, a friendly amendment, so that it is not the Sentencing Commission that staffs this commission, but it is the University of Maryland Criminology Department. And we would urge you to accept that as a friendly amendment and urge you to give a favorable report to HB 1423.
Yeah. Hi, everyone. My name is Stephen Gravatt, and I'm here to provide a juror's perspective on the felony murder rule. My testimony is relevant to this bill, HB 1423, because examining the disproportionate impact of the felony murder rule on non-white Marylanders is one of the items that the commission created under this bill will be tasked with. As some of you on this committee may recall, I was alternate juror number 1 for a trial where the defendant was charged with armed robbery and felony murder in the first degree. The defendant participated in a robbery where his accomplice accidentally killed the victim with a box cutter. As a juror, I was torn between competing duties. On the one hand, I wanted to do the right thing, and condemning a non-murderer to murder one did not seem like the right thing. But on the other hand, I wanted to do my civic duty and apply the laws of the state as best I understood them, which meant finding a non-murderer guilty of murder. As an alternate juror, I did not end up participating in deliberations, but I later learned that the jury found the defendant guilty of armed robbery but innocent of first-degree murder, which is a logically inconsistent finding. My takeaway from this experience is that the state of Maryland should not be asking its citizen jurors to enforce a law that is either so illogical we're liable to misunderstand it, or so contrary to our sense of justice that we choose to disregard it. Beyond this, if non-whites are disproportionately tried for or convicted of felony murder, it places the further burden of asking jurors to be instruments in meting out racially biased standards of justice. Please recommend passage of HB 1423 in order to examine if and how the felony murder rule and other criminal justice practices create unjust outcomes for non-white Marylanders and burden jurors with complicity in this injustice.
To the gentleman in the middle, I didn't get, I didn't hear your name. Were you favorable with amendments or favorable?
It's Phil Karoom, and I am favorable with the 2 friendly amendments that you've heard about. One is adding the public defender and the attorney general to the commission, and the second friendly amendment would be, currently the bill is drafted, says that the Sentencing Guidelines Commission would be a staff together with legislative services, and Sentencing Guidelines Commission has requested that it be substituted that the University of Maryland or some other academic institution would do that staffing.
I asked that question because I'm curious about something you mentioned. You said plea bargains, and so I'm trying to determine what is the connection between plea bargains and the commission, because oftentimes plea bargains can be a way to offer concessions while trying to feel like some justice, has been served and perhaps the perpetrator is paying justice. I'm trying to figure out the connection there between plea bargains and this commission.
So I think what the charge of the commission would be is to study racial disparities up and down the line, from initial arrest to charging to plea agreements, the plea bargain, and sentencing. And it's been pointed out that what happens inside the Division of Corrections is also important. So plea bargaining would be part of that. What one hopes for is perhaps there could be an extensive study to see within the same jurisdiction, if you have individuals charged with the same kind of background, the same kind of offense, if there are significant disparities that don't seem to have any other explaining factor than race. If that were shown, that would be an important thing for the public to consider, and what the remedies are, could be different depending on the sources of those disparities. One of the disparities that is pointed out in the Harvard, Massachusetts study is that the charges start out much greater against African Americans than whites. So that may be a big part of it, but it may be other things.
Okay, thank you. I still don't see the connection, but I could talk to the bill sponsor. Thank you, Mr. Chair.
Delegate Boucher.
Thank you, Chair. This question is for the juror. Thanks for being here and sharing your experience. As a juror, did you find the title of felony murder a bit misleading, confusing? And as a juror, do you think it'd be better to have that charge renamed and the sentencing and guidelines be different than they presently are?
So, yeah, I had never heard of felony murder before I was a juror. I was very surprised. I was surprised to learn that someone could be found guilty of first-degree murder in particular when they had, clearly not premeditated a murder. So that was very surprising to me. When I first heard the term felony murder, I assumed that just meant murder, and murder is a felony. So I did find the title misleading. I also, incidentally, had no idea, and Delegate Arikin asked me about this last week, and I wished I had one thing I wish I had more clear is that I had no idea that that the jury didn't have to find, that there was the option of jury nullification. That is something I learned later. So if I was in that jury room, I would have thought that if I thought the defendant was guilty of armed robbery, that I had to convict of murder in the first degree. So does that answer your question?
So in other words, you would be supportive of possibly renaming the charge and restructuring how it's sentenced? Would that help a juror?
So I specifically think that first-degree murder is very clearly too onerous a penalty. So I think that I think it makes sense to rename it since the name is a bit misleading, but I was able to understand the concept that if the person, as a juror, I was able to pretty quickly understand the concept that if a person is guilty of a felony that results in a murder, then they can be charged with the murder. Sure, I could see advantages of changing that name because it's a little misleading, but I think the bigger issue is that the penalty shouldn't be so high.
All right, thank you very much.
Yeah.
Seeing no further witnesses, thank you very much. That concludes the testimony on House Bill 1423. We're going to go now to House Bill 1186. Delegate Miller. Patrina Mosley. All right, bring up Patrina Mosley.
Is it okay if I bring my panel?
Yes, and Brooke Myrick. All right. Jonathan Alexander, Deborah Mercado, Tiffany Chianci, Ryan Chianci. Delegate Miller for 3 minutes, please.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the esteemed Judiciary Committee. I am Delegate April Miller, and I am here to ask for your favorable report on House Bill 1186, which is cross-filed with Senator Carrozza, and I thank her for her leadership on this bill. This bill prohibits a person from knowingly and willfully causing another person to ingest without their consent an abortion-inducing drug through fraud, coercion, threat of force when the person knows or believes that the other person is pregnant. This legislation recognizes non-consensual or forced ingestion of an abortion-inducing drug is a crime with penalties. I would like to first address what HB 1186 does not do. It does not restrict a woman's access or right to choose an abortion. It is narrowly tailored to make it a crime that if that right is knowingly taken away from her, if her choice is taken away, it is a violation of her constitutional right in Maryland. Nor should a health care provider giving medical advice to a patient be construed as coercion in this bill, as long as the provider is not the offender. I am open to a clarifying amendment. Again, this bill is narrowly tailored with the intent to protect victims of domestic violence, sex trafficking, as well as victims of sexual assault and sexual abuse and other vulnerable women. And any opposition, I would be happy to work with on addressing any of their concerns, because I did find some of the questions that were raised to be very valid. Last year on the floor, you may have heard the statement that no one in the state of Maryland is forced to have an abortion. I am sitting with strong and brave women who are here to share their stories, their truth with you. As they do, I would like you to remember women like Laura Whalen from Olney, Maryland, who are no longer here with us to share their story. In 2017, Laura was 4 months pregnant with her little boy she named Reed when she was killed by her boyfriend because she was pregnant and wanted to keep the child. In Maryland, pregnancy-associated homicides are 10 times more than the national average. This General Assembly passed the Lauren Reed's bill in 2019, which makes it a crime of violence against a woman that the perpetrator knows or believes is pregnant, an additional felony. HB 1186 has a similar purpose, as forcing an intimate partner to ingest abortion-inducing drugs because she is pregnant is an act of domestic violence, and I agree it should be amended to upon conviction that the person being subject to up to 10 years of imprisonment rather than the 25 that's introduced in the bill. I want to quickly highlight, because you're like, this could never happen. This could never happen in Maryland. In May of 2024, a woman in Massachusetts lost her child when her boyfriend, Robert Kawanda, went through an online pharmacy to obtain misoprostol, which prosecutors say he orchestrated a call from a fake nurse to advise that the victim could take an iron pill due to her low iron levels. Kawanda then showed up at the victim's home with the supposed iron supplements and even checked her mouth to ensure that she had consumed them. The woman miscarried the next day. There are more and more stories that are horrifying, but I am going to turn it over to my panel. Thank you, Mr. Chair.
Who would like to go next?
Okay.
You want to go?
Do they tell me to go? Ready to start? Okay, go ahead. Honorable delegates, my name is Tiffany Cianci. I'm a Frederick resident, small business owner, and the proud president of a franchisee association or union. I'm here today to testify in support of 1186 because I never imagined I'd be speaking about this issue. My husband's a federal attorney. We built our American dream here in Maryland. I owned a successful franchise serving children in Frederick County until a private equity takeover destroyed our business and sought to destroy our union. This firm, Seidler-backed Unleashed Brands, has spent an estimated $10 million aggressively pursuing me with lawfare across multiple courtrooms, forums, states, and different jurisdictions to silence me and to intimidate thousands of other franchisees. Their retaliation took a horrifying turn when I became pregnant during our legal battle. When I was suffering complications, their attorneys at DLA Piper saw an opportunity for exploitation and leverage. They filed a motion to force me to schedule an expedited abortion, an abortion I did not want, knowing I was a Catholic woman that did not want any abortion activity in my pregnancy. My child was very much wanted, conceived after 3 years of trying. When the arbitrator denied their request, they persisted, even contacting Johns Hopkins to confirm that there was an appointment available for me. When I still refused, they threatened sanctions if I did not comply by the following night at 7 p.m., an emotion I could not afford to fight. I had no money left to fight in the battle. I was exhausted, terrified of what they would do next. I couldn't afford to fight a sanctions motion, and so I capitulated. I scheduled an abortion, and I fought to avoid it. The cruelty did not stop there. Due to a rare side effect, I endured contractions for the next 6 weeks after the procedure. They deposed me while I was in labor, forcing me to answer questions while I was breathing through and crying. This is not justice. It was an abuse of power weaponized through a corrupt legal system. Coercion takes many forms, and no one, not a sex worker, not a mistress, not a mother fighting for her child, should ever be forced into this decision or an impossible position like I was in. This law could have protected me. It would have given me a path to seek protection in this state from a corrupt court in another state. I urge you to please pass 1186 to send a clear message that coercion is unacceptable in any form and will never again be a weapon for unethical legal conduct or for misuse in the state of Maryland. Thank you.
Thank you. Whoever would like to go next, please.
Thank you, the committee. I appreciate your time on your letting us speak here today. I'm here to support HB 1186 and really to support my wife. It's really quite unimaginable that I'd be sitting here testifying today as a member of the bar. Just so you know, everything she says is backed up by receipts. We have the email. She brought them with her today. I'm a niche lawyer, and I initially became a lawyer really because I thought I was going to have to defend myself against the state. That is clearly not the greatest threat in my life. I could never have imagined the lawyers that conducted this against my wife, Norman Leon of DLA Piper, Laura Sixkiller, former of DLA Piper, now with Greenberg Trial Rig, and Madeline Cordray, all collaborated with their client, Unleashed Brands, to bring this horrific conduct against my wife. This very conduct has shaken my faith as a lawyer and questioned the very validity of the bar itself. It is well known that the lawyers owe a duty to their clients to zealously advocate them. Unfortunately, at this time, that duty is now used to commit barbaric acts on their adversaries. This is not hyperbole. I wish it was. Every single attorney that I've been interacting with who does not believe me, when I show them the receipts, they're aghast. My wife submitted a bar complaint in Arizona seeking for them to be disciplined. Most of those attorneys are barred in Arizona. One is barred in New York and Illinois. The Arizona bar decided not to investigate any further because no one had filed a complaint previously against them. Now, based off what I just heard the Attorney General say, wouldn't that have been convenient for so many of those individuals to have gotten that privilege to not have to be investigated further? The bench also is not in a position to correct these injustices if they've taken no authority to combat it. During our founding, Alexis de Tocqueville came to our country and broadly said that the bar was going to be a mechanism to buttress against the flares of the public. This couldn't be, my wife's case just clearly contradicts that the bar is in any position to actually hold themselves accountable anymore. It has also been said that prosecutors with a stroke of a pen can alter the trajectory of someone's life. Clearly, this is the inherent authority of all attorneys. And lastly, AAA, along with the arbitrator in our case, Patrick Irvine, basically, at the end of his decision, said that not only did my wife ask for this depraved conduct be placed upon her, but that she deserved it. This is unimaginable.
Thank you very much. Whoever would like to go next, please.
Good afternoon, Deborah Bricado, retired nurse and former volunteer of over 8 years at a pregnancy resource center. I am strongly in favor of House Bill 1186. At the Pregnancy Resource Center, I heard far too many stories of coerced abortion, so it is happening here in Maryland. They were forced by their mothers or boyfriends and suffered psychologically and emotionally from being forced to end their pregnancies. These were surgical abortions, but abortion pills are the new, easier, and secretive way to force abortion upon women. The two drugs used are mifepristone and misoprostol. Misoprostol can be used alone. It is prescribed to be taken in several doses slowly to bring on contractions. The FDA recommends these pills only through 10 weeks of pregnancies. Risks for failure of complete abortion and adverse events increase with greater gestational age and the presence of other existing diseases or conditions. Those risks include hemorrhage, sepsis, and death. Telehealth has greatly increased access to these dangerous pills and provides a loophole for abusers. An in-person exam is not required, therefore it's possible for someone to get a prescription and use it on someone else. And because misoprostol is also used to treat ulcers, a man can get these pills. The abuser can crush the pills and put them in a woman's food or drink or trick her into taking them by some other method. The abuser does not care about proper dosing of these pills or about FDA recommendations and contraindications to take them. Giving her these pills all at once not only will cause extreme pain, but the contractions from the contractions, but increase the likelihood of permanent injury up to and including death. Without knowing she has ingested abortion-inducing drugs, the woman might think she is having a natural miscarriage, go to an emergency room, but be unable to give complete information on her condition. This is a very sinister and violent crime against a woman. She is being targeted because she is pregnant and has chosen to continue that pregnancy. This crime deserves special consideration and its own statute. A woman shouldn't be targeted simply because she is pregnant, and the Maryland Constitution recognizes her right to continue a pregnancy. I recommend a favorable report on House Bill 1186.
Chair and members of the committee, my name is Jonathan Alexander. I'm an attorney and legislative counsel for the Maryland Family Institute in support of the Women's Freedom from Coercion Act. This bill addresses a growing crisis, which is the abuse and coercion of women through the non-consensual administration of abortion-inducing drugs, forcing women to take the abortion pill. There are real-life cases across the country, real-life cases that demonstrate the urgent need for this law. In Texas, just this past year, a husband repeatedly laced his wife's drink with abortion drugs, caused cramping, led to the premature birth of the child, injuring the child. Virginia, right next door in 2018, a doctor secretly spiked his girlfriend's tea, ended that pregnancy at 17 weeks. In Florida, 2014, a man forged a prescription and tricked his pregnant girlfriend into taking an abortion pill. In Washington State, a nurse practitioner, after an assault and a rape, forced abortion drugs into the woman's body without her knowledge, and this resulted in the loss of her pregnancy. These are not hypothetical situations. They are horrifying realities that demand action. Without these bills, predators are armed with the now proliferation of abortion drugs. They can exploit telemedicine. They can use mail order to get these pills to commit violence against women. And so HB 1186 provides justice for the victims, but it also, as it's punishable by either the 25 years as it states in the bill or the amended form 10 years, it allows Maryland to get closer where we need to be, which is punishing these predators, giving recourse to victims. Ultimately, this bill is about protecting women. It is ensuring that no one is ever forced or deceived into ending a pregnancy against their will. So I urge you to stand against this coercion, stand against abuse by voting in favor of 1186.
Questions? Delegate Valentine?
Thank you, Mr. Chair. Thank you, Delegate, for bringing the bill, and thank you, panel, for being here today. My question, I have a few questions for Tiffany because it's just what you just explained was horrific. My question, I guess, first off is, how does an Arizona attorney threaten or coerce someone from Maryland, and like how were you threatened or coerced?
So franchisees all have contracts that they can choose any form of law they like. Most franchisors, including Maryland-based franchisors, choose a form of law for Arizona or Texas where there's the smallest amount of protections for small businesses. I was forced first into court in Arizona and then to a secret arbitration. They applied immense pressure leading up to the actual motions to compel with my secret arbitrator. Arbitrations come with a confidentiality agreement where you're not allowed to go and talk to the press or seek help. You have a non-disclosure agreement, a non-disparagement clause. You can't go anywhere. They were able to apply immense pressure. When I was first put on bed rest, they subpoenaed me to Arizona repeatedly, over and over again, so I would have to fly or face going to jail by being held in contempt. When that made me bleed more, they threatened this. They called on the judge and filed a motion through an email asking that he be forced to, that he order me to schedule the fastest abortion possible. Knowing I did not want it, it was in my medical records. He declined. Then they asked that he order me to be produced bedside. He declined. Then they closed the proceeding. I couldn't afford to go back before the judge. I didn't have enough money in my account. To go back in arbitration, you have to pay for each visit. She sent an email and said that if I didn't do it by the following day at 7 p.m. Mountain Time, that they would file motions against me and a sanctions motion, which can cost $20,000 to defend against. The joke was on me, frankly, because as soon as I actually scheduled it and did it, she filed the sanctions motion anyway. So.
Can I have one more question? Thank you. Based on your experience, I'm trying to just determine if you've heard of or trying to feel if other people in Maryland are at risk of this. Have you heard of this happening to anybody else?
So I've actually had lots of whistleblowers come to me secretly and tell me that during their arbitrations, they've either been asked to skip medical treatment or have medical treatment forced upon them. The company that I'm fighting, the chairperson of the Federal Trade Commission, Lena Khan, called my case the worst example of franchisee retaliation and abuse in modern American history. They've issued 2 new rules because of my case. But my case is just one example. The company that did this to me has done this, has taken really aggressive legal tactics with thousands of small businesses across the United States, including others here in Maryland. They just purchased Sylvan Learning Systems, which is a franchisor with thousands of franchisees based out of Towson. And all of those franchisees form their contract law in Maryland. If they tried to do this to any one of them in any state, they could fall back on this law to protect themselves. So it wouldn't just protect me, it wouldn't just protect the other small businesses that are being increasingly exploited by very aggressive and vicious tactics. It would support and protect all of those franchisees.
Thank you, Mr. Chair.
Thank you, Chair. And Delegate, thank you for the bill. Is this a law in other states, or is anybody proposing this in any other states? Do we know?
Coincidentally, it's a law in Arizona, the state where they did this to me, and I went to the state and sought prosecution. Unfortunately, the Federal Arbitration Act and the Arizona arbitration statute prohibits calling anybody affiliated with the prosecution of an arbitration with actually testifying. And because I was not an Arizona resident, they declined to prosecute the people that did it to me, saying I instead could go to the state bar. Unfortunately, it was unbeknownst to me they were about to appoint my arbitrator, Patrick Irvine, as the head of character and fitness for the state bar, and I was overruled. So they declined to sanction any of the lawyers that did it because it was his courtroom, and that was not going to happen. They actually removed my investigator the week he was appointed, the one who was taking it seriously, and they chose not to enforce their law.
Were you able to file litigation with Arizona or in Arizona?
Unfortunately, when you have an arbitration agreement, your ability to sue ends with the arbitration, and you can't seek anything after that.
All right, thank you.
Any further questions? All right, thank this panel very much, and we'll take the two people who are on virtually now. Ms. Myrick, would you like to go ahead, please, for 2 minutes?
My name is Brooke Myrick, and I am a healthcare team manager for Heartbeat International. Through our affiliate centers who every day assist women making pregnancy choices, we often hear of abortion decisions that were not made by the pregnant woman herself, but rather made by others against her will. An abuser is able to force an abortion on a woman with a pill that is readily accessible or add it to her food or drink without her knowing. In addition, as a nurse overseeing the abortion pill rescue hotline, we receive calls frequently from women who have started a chemical abortion under coercion or force. Women have called our hotline who have been assaulted as abortion pills are physically forced into their mouths. Others have been poisoned by a person they trusted who secretly added abortion pills to their food. Some have been locked in rooms or closets and only freed once they relented and took the abortion pills against their own wishes. Once these women are in a safe place, they are so desperate to continue their pregnancies, they call our hotline for immediate assistance. This underscores that in these instances, the abortion decision was never the woman's free choice, but rather a decision made by another. One woman who called our hotline just 1 week ago said her husband gave her no choice but to swallow the first pill. After he left her, she desperately searched for assistance and found our hotline. Within 1 hour, she was connected with a physician who provided medical care to save the life of her child, as well as urgent resources to ensure her safety. As the abortion pill becomes more readily available, provided through telehealth and through more than 70 websites, such cases are now commonplace. We support this bill, which provides criminal penalties for anyone who forces a pregnant woman to take abortion drugs without her knowledge or consent. Thank you for taking my comments into consideration.
Ms. Mosley, please, for 2 minutes.
Thank you. I'm here today to urge a favorable vote for the Women's Freedom from Coercion Act, HB 1186. I will begin to tell brief stories of these women by name. In 2013, Remy in Florida was 6 weeks pregnant when she trusted her boyfriend who said he was giving her medicine. In 2017, Brooke from Arlington, Virginia was 17 weeks pregnant when she realized her boyfriend had drugged her tea. Jane Doe in 2019 from California was held at gunpoint by her boyfriend and told to take pills that resulted in her pregnancy loss. And in 2023, Catherine from Texas was 7 weeks pregnant when she was drugged by her husband. These are just brief snapshots of the violence against women that happens all the time because someone else wants control over their bodies by any means necessary. As a women's advocate in the spaces of human rights and anti-exploitation for over a decade, and a volunteer in my community for survivors of abuse and unplanned pregnancies, I can tell you for a fact that pregnancy increases a woman's risk for violence or worse. Homicide is the leading cause of death during pregnancy in the United States and intimate partner violence often includes reproductive coercion. At the same time that these risks have increased for women in violent situations being pregnant, there has been unfettered access to reproductive drugs online amongst 100 or so websites. And these chemical substances terminate pregnancies, and they are unknown to the woman that it is being done. A New York Times investigative piece showed just how easy it was for him, the author of this piece being a male, to purchase these drugs online. Times are changing, and with this new accessibility, it can and it has empowered abusers to have complete control over a woman's reproductive decision. It is time to pass the Women's Freedom from Coercion Act as the most modern way today to protect women from violence. Thank you for your time today.
Questions? Seeing no further questions, we thank you all very much. And that concludes the testimony on Delegate Miller's bill, House Bill 1186. We're going to move on now to Delegate Valentine and his bill, House Bill 1202. We'll ask Moreau Williamson, Jason Steinhardt, Matthias Cachero to come forward. We'll hear from Delegate Valentine for 3 minutes, everybody else for 2.
Thank you, Mr. Chair. Good afternoon, Chair, Vice Chair Bartlett, members of the House Judiciary Committee. For the record, Delegate William Valentine, District 2A, representing both Washington and Frederick counties. I'm before the committee today to present House Bill 1202, Criminal Law, Drug Trafficking Crime Definitions. Criminal Law 5-621 criminalizes the use of a firearm in a drug trafficking crime. The policy reason for criminalizing this behavior, in addition to the drug trafficking crime itself, is reasonable. The presence of a firearm in a drug transaction dramatically escalates both the probability of violence and the level of violence should it occur. This conduct is particularly harmful to communities, and a not insignificant percentage of gun violence, or at least somewhat related to drugs itself, and as a result, tearing many of our communities apart. After the possession of recreational and use in cannabis in certain amounts was legalized under Maryland law, cannabis offenses that used to be felonies became misdemeanors. While this change makes sense, one unintended consequence of this change was to render individuals who engage in drug trafficking offenses involving cannabis while using a firearm ineligible for prosecution under the statute. This means that an individual illegally distributing cocaine while using a firearm is subject to this offense, but an individual illegally distributing cannabis while using a firearm is not, despite the threat posed by a firearm being exactly the same. This bill remedies this issue, restoring the ability to prosecute those that engage in a drug trafficking crime while involving cannabis while using a firearm without increasing the penalties for the cannabis-related offense. This bill is a narrowly targeted bill that closes a loophole that currently allows some drug offenses to individuals engaged in drug distribution to escape a liability for using a firearm, and restores this important tool to Maryland prosecutors. As you'll notice, there's no opposition testimony to this legislation. I respectfully request a favorable report and will defer to my panel for more details.
Whoever would like to go next.
Chairman Klippinger and members of the Judiciary Committee. My name is Jason Steinhardt, and I'm an Assistant State's Attorney in the Office of the State's Attorney for Anne Arundel County. I'm also the trial team leader of the Felony Narcotics Section, where we prosecute crimes related to CDS distribution and firearms. House Bill 1202 amends the definition of drug trafficking crime as specified in Criminal 5621 to include a misdemeanor in violation of 5602. But to put it in layman's terms, this places possession with intent to distribute cannabis back within the definition of drug trafficking crime, which it most definitely is. In the past 5 years, I've prosecuted at least 3 homicides, all involving firearms, related to the illicit sale of cannabis. There were understandable reasons for reducing possession with intent to distribute cannabis from a felony to a misdemeanor in 2023, based in part on the perception that cannabis is less harmful than other drugs such as fentanyl and cocaine. I'm not here to change anybody's perception of that, but the introduction of a firearm into the equation of illicit sales is just as dangerous, regardless of the substance that's being sold. Firearms are still frequently used as the enforcement mechanism in violent acts such as armed robberies and homicides related to drug crimes. Robberies and other violent acts related to drug sales occur whether the substance is cannabis or any other drug. The danger lies in the person possessing the firearm, and this modest amendment places the focus of prosecution back to the illegal firearm rather than the substance. A drug dealer in possession of a firearm where there's a proven nexus to the drug trafficking crime is just as dangerous whether that substance is cannabis or any other controlled dangerous substance. I urge a favorable report for House Bill 1202. Thank you.
Good afternoon, Chairman and members of the committee. My name is Moreau Williamson. I'm an assistant state's attorney here in Anne Arundel County. I've been a prosecutor for 17 years, and I've been in the felony narcotics unit in my county for 10 years. I'm testifying today on behalf of the Maryland State's Attorneys Association. The purpose of HB 1210 is simple. It is to bring possession with the intent to distribute cannabis and manufacturing cannabis with the intent to sell back into the definition of drug trafficking with a firearm. Previously, these two crimes fell within the definition, which applies specifically to drug felonies. Since these two crimes have been made misdemeanors, a loophole has been created in the law. We are not talking about cannabis users or cannabis that is sold within the current regulatory framework in the state of Maryland. We are talking about people selling drugs with a gun. The focus of this bill is the presence of the gun, not the particular substance that is being sold. Dealing or manufacturing drugs with a firearm creates a dangerous situation, no matter what the substance being sold is. A gun in connection with a drug deal is just as deadly whether someone is selling fentanyl, PCP, Suboxone, or cannabis. In Montgomery County, there have been 18 cannabis-related murders in the last 3 to 4 years specifically. I have personally handled a murder related to a cannabis deal in which 2 separate firearms were fired in the commission of that drug deal, both on the buyer side and on the seller side. Cannabis on the street remains a valuable illegal commodity, and people will take measures to protect it. On the street, cannabis can be worth $150 to $200 an ounce. By a pound, that is $2,400 to $3,200 based on the quality of that particular cannabis. Based on the potential and actual violence that comes from selling drugs with a firearm, no matter what that substance is, I urge a favorable report on HB 1202. Thank you.
Dear Chair Clippinger, Vice Chair Bartlett, and honorable members of the committee, I'm here to support House Bill 1202 on behalf of the Office of the State's Attorney for Baltimore City. My name is Matias Cacheiro, and I'm the Deputy Director of Government Affairs for the office. This bill addresses a critical gap in our law enforcement and criminal justice process. At its heart, like my colleague said, this is a gun bill. This bill intends to ensure that the most grave perpetrators of violence in our communities face accountability. By changing the definition of drug trafficking crime to include misdemeanor charges or conspiracy to commit a misdemeanor, we're ensuring that anyone distributing drugs with a firearm is held accountable. Legislation that has decriminalized cannabis-related crimes over the years has been essential to address systemic and structurally racist policies in Baltimore City and the state of Maryland. However, demoting criminal cannabis charges to misdemeanors has left a gap in combating armed drug traffickers. It has inhibited the ability of law enforcement and prosecutors to hold accountable individuals who carry firearms while distributing cannabis. Under current law, an individual can drive around your neighborhood with vast quantities of cannabis and a firearm intending to distribute, and only be charged with 2 misdemeanor crimes. If that same individual holding a small bottle of fentanyl pills and a firearm and handing them out, that individual will be charged with drug trafficking crime and face a minimum of 5 years up to 20 years. The danger we are trying to address with this legislation is the firearm. Holding criminal dealers accountable and removing dangerous weapons from our street is an essential step in keeping Marylanders safe. Despite the changes in cannabis legislation, an underground economy for cannabis still exists, and our prosecutors still see cannabis as a key factor in a lot of homicide cases. This year, our prosecutors have already had to deal with several cases with this exact issues where individuals had large amounts of cannabis and were driving around neighborhoods with firearms. I'm from Montgomery County, and there was a case in Gaithersburg where an individual was murdered over a cannabis deal gone wrong. So this is an issue across the state, and I urge you to give a favorable report. Thank you.
Questions, Delegate Boucher?
Thank you, Chair. Is it my understanding that the legalization of cannabis has not had the effect we were told that would reduce the illegal distribution of cannabis?
So there's still quite a bit of distribution of cannabis in Maryland. In Anne Arundel County, we have BWI Airport. We constantly have cases where people bring pounds and pounds and pounds of marijuana from other states into Maryland in heat-sealed bags. There's still plenty of dealing going on.
And that's organized crime and they're armed with firearms?
Sometimes.
Thank you.
Delegate Cardin?
Thank you, Mr. Chair. Thank you very much for the bill. I think it makes a lot of sense. Ms. Williamson, right? Quick question. So what you'd specifically said this is not about going after the legal or the call it legal, the organized cannabis growth and distribution that the state has created. Correct. In terms of the licensing. If we pass this, is it possible that these legal entities that are not necessarily federally legal entities could get caught up in this because there's not that's question number one is would that, I don't know exactly how to ask it. Question number two is, many of these groups have armed guards and armed people who are delivering perhaps cannabis through a legal system that the state has developed or permitted. And could they get caught up, even though they may be contracted out, but still be, carrying or distributing cannabis, carrying a gun? I mean, just wondering. I just want to make sure we're not doing the wrong thing.
It's a valid point. That is not the intent of this bill. And I can say throughout Title V, which is the title of the criminal article in Maryland, it says in violation of this title many, many places. So if that wants to be specified, selling in violation of this title, because if someone is selling drugs at a dispensary, they're not selling it in violation of this particular title. This bill is specifically targeted at people on the streets walking around with cannabis and a gun. A search warrant on a house, for instance, if someone executes a search warrant on a house and there's a pile of cannabis and money and a gun and scales
I understand. That's not what I'm asking about. But if you go into a warehouse that is licensed, right, and there's a pile of cannabis and a gun, right, they may actually be legit.
So that would not be in violation, in my view. This would not be in violation of this title. Okay. And if people are permitted to carry firearms in places like that under other laws, then that wouldn't be.
Thank you. Thank you. Just want to make sure.
Delegate Tomlinson.
Thank you, Mr. Chair. My question's for either of the assistant state's attorneys. So especially in the last couple years since cannabis has been legal, can you just talk a little bit about some of the violence you guys have seen, especially if it, like I said, if it's been in the last couple of years since the major law changes?
I can speak to some of the cases that I personally handled. I will say, just in the interest of disclosure, they might not have happened since 2023. I prosecuted this since 2023, but I can tell you the trend hasn't changed much. I prosecuted a murder that happened a couple blocks away from here, over on Pleasant Street. I actually had two cases, but only one involved cannabis. Two young gentlemen from Baltimore came down with a relatively hefty amount of cannabis, where they were held up at gunpoint by multiple individuals, and the root of it was a dispute over cannabis and money. And I've had this on both sides. I've had this on people interested in purchasing cannabis using firearms, but also drug dealers who are carrying firearms as well. And so a young gentleman was murdered on Pleasant Street by a young man from Annapolis. This is a case that went to trial in January of 2023, and he was found guilty of a first-degree murder. And it's just unfortunate. So We have provided a legal and safe way for adults who want to purchase cannabis to do so, but unfortunately that hasn't dented the illicit sales that still happen, many of them with firearms. Other cases in Glen Burnie that I prosecuted as well was the same thing, where the drug dealer actually brought along a firearm and shot 2 young men who were purchasers over a dispute over money in a laundry room. And these are cases that have been affirmed on appeal. So there are quite a few of them, unfortunately, far too many than any of us would like to see.
Thanks.
Are there any further questions? All right, seeing none, we thank you all very much, and that concludes the testimony for House Bill 1202.
Thank you.
Going now, wait, who? House Bill 1350, but she's always here, but she's never actually put in a bill before.
Oh, come on.
Oh, that's so
I spend a lot of my time in HGO where they absolutely love me.
But I think this is your first bill in, it's not?
No, come on now. I've put in bills.
It just feels like it.
It's been a few years.
Oh.
I prefer to sit on that side, frankly, and throw low balls.
Well, everybody get ready here for about 10 minutes from now.
Yep.
For
This is
question
actually
time.
going to be super fast. You're
House Bill 1350. Go
Yes.
ahead, Delegate.
Thank you. Mr. Chair, Madam Vice Chair, my good friends of the House Judiciary Committee, Lauren Arkin for the record. This is House Bill 1350. It is a simple bipartisan bill, and it goes into the part of the code that some of you might remember us working on, which was the person in a position of authority section. Essentially, what I feel is that it closes a small loophole that I don't even think we intend. Oh, we've already got a question. Great. Oh, another one. Oh, goody. It's small and simple, and it oh, good, great. And it tweaks the part where there is an enhanced penalty for a repeat offender. Basically, how I came across this bill was I was sitting in the waiting room of the courthouse myself, and a delightful assistant state's attorney said, "Hey, could you fix this problem I'm having?" And I was like, "Well, tell me about it." And this is what he said. There was an out-of-state offender, repeat offender, who came to Maryland, offended in Maryland, and he was not able to get any enhanced penalties against the person because for some reason our code did not include enhanced penalties for out-of-state conviction. That is exactly what this bill addresses. It makes it so if someone has committed these offenses, these fourth-degree sex offenses out of state, we can also consider them here in the penalties portion and make sure that they're getting the proper penalty for the crimes they've collectively committed. So with that, I will pass it to my panelists. Yeah, you want to go?
Sure, I'll go. Mr. Chair, Madam Vice Chair, members of the committee, I am Allison Healy. I am the State's Attorney for Hartford County and a board member of the Maryland State's Attorneys Association. I am here today to offer my support for House Bill 1350. Criminal Law 3308 provides a subsequent offender penalty for offenders who have previously committed enumerated prior sexual offenses, increasing the penalty from 1 year and/or $1,000 to 3 years and/or $1,000. The intent of the subsequent offender penalties is to more severely punish repeat offenders. However, currently, the statute only applies that subsequent offender penalty only for prior convictions in Maryland. House Bill 1350 simply permits those repeat offender penalties to apply to individuals who have committed the same enumerated offenses in other jurisdictions, as well as including other states, federal, military, or Native American tribal courts. It should be irrelevant that a prior conviction occurred in a different jurisdiction. If a sexual predator has reoffended, he should be subject to the same criminal penalties as a subsequent offender as an individual who committed a prior offense in Maryland. A prior sexual offense is a prior sexual offense and should be treated as such. We must hold sexual offenders to the strictest penalties for the benefit of all of our citizens and public safety generally. For these reasons, I respectfully request a favorable report for House Bill 1350.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. On behalf of the Maryland Coalition Against sexual assault survivors across the state of Maryland, and for the reasons stated by the prior witnesses, we urge a favorable report on House Bill 1350.
That was easy. Ms. Feinstein, please, for 2 minutes or less.
Good afternoon, Chair Clippinger, members of the committee, Debbie Feinstein with the Montgomery County State's Attorney's Office on behalf of the Montgomery County State's Attorney's Office and the Maryland State's Attorneys Association, as well as the Special Victims Subcommittee of the Maryland State's Attorneys Association. I support the prior testimony and urge a favorable report on 1350. Thank you.
There are a number of lights flashing. We'll see how many of them actually have questions. All right, starting with Delegate Simmons.
Thank you, Mr. Chair. Thank you.
You're welcome. Isn't that so?
Some questionable co-sponsors on this bill.
Yes, it's very bipartisan.
Great job. Thank you, Delegate.
You're welcome.
Delegate Schmidt told me to hit my button. Isn't that so?
It is so. That sounds like him.
Well, I really do have a question.
I'm
Even
excited.
though
I'm
I
ready.
was told to hit my button. But I just this is for clarification. So to look at the prior acts in other places, are we just talking about, not, there's no just there, or justice. Are we talking about looking at those prior acts in terms of let's say evidence or whatever, that this is who the person is, but the person is still just going to be charged with that one, you know what I'm saying?
Correct. Yeah, she can go into more detail, but yes.
Is it like multiple?
So the way it works generally for subsequent offender penalties is we have to file notice of our intent to seek subsequent offender penalties. And so we would obviously review an individual's record, and if we were to see, like in the case that Delegate Arkan was talking about, our deputy chief of our Special Victims Unit had a case where individual had one of the enumerated offenses, but not in Maryland, in a different state. And so we could not seek the enhanced penalty because it was an out-of-state conviction and the statute doesn't allow for it. So this would allow us basically to seek that penalty for the same offenses that are already enumerated, just if they occurred in a different state. And it would have to be a conviction for us to seek those penalties.
The other states would have.
Correct. Any prior offense, it would have to be a conviction. It's not an allegation, it's not a charge. If you have to be convicted of the prior offense to be eligible for the subsequent offender penalty.
Thank you, see.
You're welcome.
Thank you, Mr. Chair. I actually put it up without a question, but now I have a question. Apologize. For one of the state's attorneys, thank you. And by the way, I love coming up to Harford County. It's a great, great case.
You
great
never
place
call me when you come.
Great place to try cases.
I'm offended.
Anyway,
we like it there too.
Enhanced penalties in other matters, not fourth-degree sex offense, but other matters. Do we have this same type of thing? So this is the only one? This is unique in that sense, or is this?
I don't know that I can say it's the only one, because that has this problem. I would be lying if I said I've memorized the entire criminal code. But I can tell you, for example, DUIs. We can subsequent offender penalty, for that, for driving while suspended. For even much more minor offenses, we can seek subsequent offender penalties, but not for this, for whatever reason.
If you check the fiscal note, there is an outline of all of it. I think
But there's precedent. Okay.
Yeah,
absolutely.
Yeah, in most offenses, we can subsequent offender the out-of-state
Thank
convictions.
Yeah.
Thank you very much, Mr. Chair. And Delegate, I actually do like your legislation.
Oh, I'm so pleased.
You did a great job here.
Oh, thank you.
And so I just have a really quick question, which is, do you think that this will be effective in discouraging those sex offenders from re-offending?
I would hope so, but as you know, sex offense is something that is very hard to deter people from doing. And so on the one hand, we want to, deter people as much as possible. But on the other hand, they have to pay for what they actually do. And if they continue to do the same thing over and over, in my opinion, they should experience enhanced punishment. Whether or not that works is really up to the individual and if they're doing some soul seeking on the other side of it.
Thank you.
You're welcome.
Vice Chair.
Chair, thank you for bringing this bill. I have about a 5-part question.
Oh, Lord.
Number 1.
Okay, I'm ready. Should have brought my glasses.
Number 1, I just wanted to ask, actually, does this only apply to 4th degree sex offense?
Yes, mine does. There are already enhanced penalties for the other ones.
That's what I wanted to know.
Yeah.
Well, then I'll not ask my other parts. Thank you very much.
Thank you so much for bringing this bill. So my question, I just made up a question. How much of a problem is this in Maryland?
You know, we'd have to pull the numbers. I have not done that. I mean, I only found out about it literally sitting in the lobby waiting for my own divorce hearing. So it was a problem that day, and he even followed up with an email, so I could tell he was committed to this.
Got it.
Somewhere out there, he's probably listening to this going, that's my bill, you know.
Right.
Well, hilariously, when the delegate emailed me about it, he was sitting in my office and said, "That's my bill." And I said, "Then I'm going."
Okay, cool. Yeah. Thank you.
Delegate Simpson.
Thank you, Delegate, for bringing this bill. So I was going to, ask if you felt like it was going to make a difference, but I guess instead I'll say, are you done testifying yet?
Yes, I am done, and I'm ready to move on to the next bill, Mr. Chair, if you're ready.
Except there are two more people.
No, Lord.
Oh, no.
What? Couldn't see you. Oh, my gosh.
Well, actually, it was, thank you, Mr. Chair, but it was already asked, so I've kept my light on, so I appreciate it. So now I had a question yesterday, now you're my second question, so thank you.
Good, yeah, well, we're really glad to have you, and welcome to a really fun place.
All right, thank you.
Thank you, Mr. Chair.
For the last question.
And Delegate Aricon, thank you for bringing this bill. And I said it right, too.
You did. I'm very impressed.
But this is for the state's attorney, because I really do want to understand, if I'm charged in a different state, sometimes what we might say is a fourth-degree sex offense, and this is educating me. Sometimes we might say it's a fourth-degree sex offense. It's something different in another state. How do the state's attorneys deal with that so we know that we're dealing with apples to apples?
So we would go and get the statute from the other state and figure out which section. So fourth degree here in Maryland is the lowest degree of sex offense that we have. So we would go and look at the facts and, well, the charging language as well as the facts of that case to sort of determine which section of our sex offense statute that particular charge would fall under. And then we would file the notice, and obviously, if the defense wanted to challenge that, we would make the argument, a legal argument, as to this is a subsequent offender because the elements of this crime in, we'll use Pennsylvania, right, are the same elements of the crime of fourth degree or third degree sex offense here in Maryland. So we would make sure that the elements of the crime and the facts that were alleged in the underlying conviction equate to one of the enumerated crimes in Maryland.
And if it was a second degree or third degree, you'd still be able to use that?
Right.
Okay.
Right.
Thank you.
You're welcome.
Okay. Thank you all very much. That appears to conclude the testimony for House Bill 1350.
Thank you.
Thank you all very much. House Bill 1282 is next, and Delegate Tomlinson, Rachel Cash. He's coming. We have 3 bills after this. We probably will get to a voting session, but we'll find out. Delegate Tomlinson, when you're ready for 3 minutes, please.
Good news is I don't have 8 panels, so it's good. Thank you, Mr. Chair, Madam Vice Chair, members of the House Judiciary Committee. For the record, my name is Delegate Chris Tomlinson, and I'm testifying on House Bill 1282. Bullying has always been around. It's been an ugly act, and it will continue to be an ugly act. However, bullying has transformed into a much larger beast over the last 2 decades due to social media and smartphones. For most of us on this committee, when we were in middle school or high school, we didn't have a phone, and if we did have a phone, it probably didn't have the internet. And you probably couldn't take pictures or video. And in addition, the term social media really didn't exist, and sites such as Facebook, TikTok, Twitter, X, they didn't, quite frankly, probably exist. So for kids who were bullied when most of us were younger, it usually came to an end once you got home. You might get, mentally or physically abused at school or on the bus or on the walk home, but usually by the time you got home, it came to an end. However, that's not the case anymore in 2025. The way it works now is if you get beat up or you get knocked out, somebody might be there to record it. And not only to record it, but they might go and upload it online to a social media site. And in that case, the torture just never really ends. The video is viewed and shared endlessly, and the pain that comes with bullying just only gets worse and continues on. Now, on to the actual bill. The bill prohibits a person from uploading a video of an action that is a crime under state or federal law to a social media application with the intent to promote or condone the activity. If found guilty, the individual would receive a misdemeanor with got a max of a 1-year sentence or a fine not exceeding $2,500. The bill is named Mackenzie's Law in honor of Mackenzie Cash. You'll hear from her mom right next to me here, Rachel Cash, in a few minutes. She's here with a group that she runs called Be a Ray of Sunshine behind me in the yellow shirts. And she'll do a much better job of explaining the importance of the bill and how bullying has affected her family's life. Similar laws have passed both in California and in Illinois back in 2017, I think it was. So for us to pass this law here, certainly we would not be the first. My state's attorney's office couldn't be here today, and I'm sure everybody's fine with that. Anything to cut down on today, but I do just want to share a real quick story. So if anybody could ask me a question, I'd be happy to share a great example of something that happened in Carroll just the other day, where if this law existed, it could have been applied. So I'm happy to answer any questions from the committee. Thank you, Mr. Chair, Madam Vice Chair, and the members of my committee. Thanks. Sorry.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Rachel Cash, and I am here today not only as the founder of the Be a Ray of Sunshine Foundation, but as a mother who's lived through every parent's worst nightmare. In December 2022, my 14-year-old daughter, Mackenzie Ray, passed away due to the devastating mental health effects of cyberbullying. She was kind, bright, and full of dreams of serving our military and becoming a nurse. Mackenzie was physically attacked, and instead of helping, bystanders pulled out their phones. They recorded her suffering and spread that video across social media, replaying her worst moment over and over again. What should have been an act of intervention became entertainment. She was humiliated, tormented, and trapped in a cycle of public shame that she couldn't escape. No child or no person should have to endure that kind of torment. No parent should have to bury their child because of bullying and online cruelty. But right now, Maryland law does not do enough to prevent this from happening again. Grace's law addresses cyberbullying. It was an amazing start, but it is reactive and not proactive. It punishes offenders after the damage is done, after a life is lost. But by then, it's too late. That's why I'm asking you to support HB 1282, Mackenzie's Law. This bill will hold individuals accountable for uploading videos of criminal acts, preventing social media from being used as a weapon against victims. When these videos go viral, they do more than fuel bullying, they shatter lives. Mackenzie should still be here. And we have the power to make sure this doesn't happen to anyone else. By passing HB 1282, we can protect victims, discourage violence, and create a safer online environment. Please stand with me, stand with Mackenzie Ray, my ray of sunshine, and support HB 1282. Thank you.
Questions for the panel. Delegate Eric Han.
Thank you, Mr. Chair. Thank you so much for being here and sharing your daughter with us. Delegate, I wanted to give you an opportunity to tell us what happened most recently in your county.
Thank you. So what happened was there was a male juvenile who picked a fight with another male juvenile in a store parking lot. It was filmed by a female juvenile and posted to social media. And it was pretty clear from the video that the male who picked the fight and the female who was with him, that it was planned with the intent to record and put it on social media. The male juvenile, he was charged with second-degree assault as a juvenile. And the state police were working with the state attorney's office asking, is there anything, are there any charges that could be applied with the woman, the the young woman who was with him. And state's attorney's office told them that, I mean, maybe you could have charged her with second-degree assault as aiding and abetting the male, but it was a stretch at best, so they did not go with that. But they were familiar with the bill that I'm putting forth, and they said if this had existed, that's something easily they could have charged her with. Yeah.
Delegate Conaway.
Thank you, Delegate and panelists, for coming to testify. My question is, if it's a mutual agreed to fight, I think they call it an affray or something like that, would that be covered by this? In other words, if two people agree to fight have a fight or an intense boxing match at the playground, and everybody is going to come and watch, and some people upload it to social media, would that be covered by this?
Are you asking if somebody could be charged who recorded it?
Yes. That's your bill, right?
Yeah. I mean, so it's pretty clear in the bill that it's not just the upload, but it's with the intent to promote or condone the activity.
Yeah. Right. What's wrong with that?
Yeah, if it could be, yes.
Sure. Okay. Thank you very much.
But it also couldn't.
Which one is it? Could or couldn't? I don't want to.
I mean, it depends. I mean,
so I'll let you just send me.
Okay. Thanks.
Delegate Carter.
Karen, thank you very much for coming, and my condolences to you and on all the trauma that you guys have been dealing with. Unfortunately, a little bit before your time, are you familiar with, this is for Delegate Tomlinson, familiar with Grace's Law?
Yes, I believe that was the senator from your county. I'm forgetting his name at the moment.
And the delegate from my county, too.
Yes.
It was my bill.
I did not know it was your bill. Okay. I remember it was Senator Zirkin, right?
Right.
And then, okay.
Okay. Well, the original bill in 2014 was my bill, and then we co-authored the second one. Anyway, that's not the point. In the new version, the 2019 version, we put in that a single significant act, it took a lot of work with this committee to get it through and with the ACLU to make sure that it was constitutional. A single act could violate the law, although it could also be a course of conduct, which is much easier to deal with. As long as the act, the electronic communication, has the effect of intimidating, harassing a minor, causing physical injury or serious emotional distress. I think that's pretty much the case, it sounds like here. And the person intends to intimidate or harass the minor and cause such injury. So the state's attorney may actually have recourse. Now, that doesn't mean that I wouldn't support this, because I am very concerned about bullying and the advent of electronic communications as a way of particularly 13 to 16-year-olds, particularly women, girls between 12 and 16 are the ones that seem to be the most vulnerable. I'm very open to it, but we really ought to, don't you think that we ought to look at whether your state's attorney could have used Grace's Law to deal with this?
Yes. So based on the 2019 updates you're referring to, it sounds like that could be an option.
Okay. All right, we'll talk about it and maybe suggest that.
Delegate Schmidt.
Thank you, Chair. And I appreciate what the good delegate from Baltimore County had brought up. I'm looking at some of the news articles here from his law. Does this take it one step further? Is that basically what this does here?
Yes.
Carries it into social media. I know we've done a tremendous amount of work across the state for anti-bullying. We work in a ton of organizations in schools, and I appreciate the opportunity to extend this a little bit further. Nobody should have to go through this. Thank you. Isn't that so?
Delegate Phillips.
Thank you for bringing the bill, Delegate, and my heart goes out to you.
Thank you.
I had a call last week about a fifth grade situation that was very similar. Fifth graders, girls, had taken someone in the bathroom and they had planned it out. At the same time, I'm really concerned about criminalizing all of our children. This is not acceptable. I'm just trying to figure out if criminalizing him is the way to fix it, and I just don't know. But my heart goes out to you. My daughter is an administrator in elementary school, and like I said, it's just happening way too young. But Delegate, I'm going to review this, and maybe there's some other tweaks we can make.
Yeah, I'd be happy to talk with you and see if we can, tighten anything up.
Yeah, thank you.
And with respect to following up on Delegate Phillips' question. Correct. But maybe going a little bit different direction. Again, what happened was absolutely horrible. I don't wish to minimize that, but reading the bill, what about an example where someone put on Facebook, this person stole a package from my front step? Has anyone seen this person?
So so you're saying like you have a ring
They
camera?
committed a crime and they're promoting it because they want to find out who stole the package.
I don't think in that case it checks the boxes of promoting
I think it
or
does
condoning an
because it says
activity.
or, it's either, it's promoting as opposed to, I don't know. I think the tricky part with a lot of these bills and a lot of the tricky parts that we had with when we did Grace's Law in the end was trying to navigate between to find that line between what is actual legitimate speech and somebody who's bullying somebody else. And that is the really difficult line to draw here. And so this is the beginning, I think, not the end of a conversation on this, but in my first glance of reading it, that was one of the first things that popped up at me. Have you seen this person? We have them on a Ring camera and they keyed my car. They broke the window on my car. And you can see the person and they're seeking to promote it. It's a crime. It's not the crime that you're talking about. But this is one of the things that we do in this committee, and it's not meant to be disrespectful, but we have to make sure that these things work all over again.
Yeah, I mean, I think
lots of different circumstances. So I'll let you respond, and then I'll go to Delegate Card.
I was just gonna say, I think we can certainly work on the language to clear that up.
I think that it was actually, I think you helped us with language in our bill that specifically said that both peaceable activity, political speech, and other conduct for lawful purposes would not implicate the law. So we can work on language, couldn't we, Delegate Tomlinson?
Yes, we can.
Okay.
Yes, we can, especially as next door neighbors and here in committee.
Any other questions? Seeing none, thank you very much. That concludes the testimony on House Bill 1282. We're going now to Prince George's delegation bill. I know Delegate Thompson, you've got another one. We're just going to roll through a couple more, hopefully quickly. Is the Mayor of Glen Arden on Kashena Cross? No, okay. So it's just going to be Delegate Williams presenting on behalf of the Prince George's County delegation for House Bill 408.
Whenever you're ready. Summary, okay. All right, I am the only person here for this bill, so hopefully this should go quickly. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the Judiciary Committee. I'm asking for a favorable vote on House Bill 408. We have amendments to this bill, and as amended, this bill simply establishes the Prince George's County Coordinated Youth Violence Review and Response Team. The purpose of the review and response team is to review cases of youth identified as being at risk of imminent harm, identify root causes and patterns within and across public systems that hinder upstream prevention of violence against youth, provide recommendations based on identified factors that hinder upstream prevention of violence against youth for quality and performance improvement, facilitate coordination and collaboration amongst entities involved in providing services to youth at risk of imminent harm, and create specific safety plans using wraparound supports for the youth identified as being at high risk of imminent harm and the youth family and community while protecting individual privacy rights as required by law. Under the bill, the review and response team must maintain appropriate administrative, physical, and technical safeguards to protect the privacy, confidentiality, integrity, and availability of any information the review and response team obtains in compliance with all relevant policy laws. And so finally, with one of the amendments, it does modify the report date to January 1st, 2027. The report must contain de-identified aggregate level information on the youth that were served and connected to services and their associated risk factors. Each member of the review and response team is authorized to review the report prior to submission to ensure the report aligns with the safeguards on data privacy and security. And this was mimicked a bit around the bill that was passed several years ago regarding Baltimore City's Coordinated Youth Violence Review and Response Team, which was HB 1310 last session. And so for all of those reasons, we are asking a favorable report for House Bill 480.
Questions?
408, sorry.
Questions? All right, seeing none, that's fine. That concludes the testimony on House Bill 408. Going now to Delegate Simpson, who is right there. And this is a Frederick County bill, House Bill 492. It's just you, which is more than enough.
Yep, it is just me. For the record, Karen Simpson from Frederick County. It is a Frederick County bill. All it does is allows the county to use fingerprint assisted technology to do some background checks. It's still, you should have in your folder, because I told nobody to come since we really wanted to get out of here, you should have the testimony from the county executive as well as the sheriff's office approves this and the delegation. So, any questions?
Questions? Seeing none, that concludes the testimony on House Bill 492. We're going to send Delegate Tomlinson back. And it's just Delegate Tomlinson, also more than enough for House Bill 1, 3, 4, 9. It's House Bill 1349. Delegate Tomlinson. I was just letting him have time to get up there. All right, and 3 minutes for Delegate Tomlinson on the last bill.
All right, last bill, no pressure. All right, thank you, Mr. Chair, Madam Vice Chair, members of the committee. Once again, for the record, my name is Delegate Chris Tomlinson. I'm testifying on House Bill 1349. In 2015, Maryland enacted the Unmanned Aircraft Systems Research, Development, Regulation, and Privacy Act of 2015, which established that only the state, not counties or municipalities, could enact law or take other action to prohibit, restrict, or regulate the testing or operation of unmanned aircraft systems. Maryland, unlike some other states, they do not have a statute prohibiting the use of drones over private property of another. So what this bill would do, it would make it a crime to knowingly or intentionally cause an unmanned aircraft system to enter the property of another and come within 50 feet of a dwelling with the intent to coerce, intimidate, harass another person, or obtain videographic or still images of the property owner, resident, or guest. And that this would not be applied to any person who gave consent for the unmanned aircraft system to enter their property, or a person who is authorized by federal regulations to operate an unmanned aircraft system and is operating the system in an otherwise lawful manner and consistent with federal regulations. If found guilty, the individual would receive a misdemeanor with a fine of $5,000 and no more than a year in prison. So similar bills have been passed in other states. One of them was South Carolina, another was Virginia. In fact, this bill is almost a mirror image of the one that passed in Virginia a few years back. I would also like the committee to know that I had tried naming the bill the No Drone Zone Act of 2025, but apparently bill drafting didn't find it as funny as I did, and they did not attach the title to the bill. Anyhow, I'm happy to answer any questions from the committee. Thank you.
Are there questions from the committee? Delegate Cardin.
Thank you, Mr. Chair. Could we just amend on unmanned aircraft onto the Valentine bill?
I was actually thinking about that earlier today.
That would be, but it's already over, we have to have the Senate do it, or send it back. That would be number one.
Right now, Delegate Valentine's like, please don't screw it.
What other violations or laws are violated by a drone going onto private property right now? Is there anything else that they could be charged with?
So, good question, and I had been working with my state's attorney's office on this because we've got a big issue with this going on in Carroll County right now with this power line that's coming through, and we've got a lot of farmers who are threatening to shoot these things down, and our state's attorney's office is saying, please don't shoot them. Unfortunately, there's not. Even a simple country lawyer is giving advice to not shoot down the drones. So a couple of the different remedies that were tossed out there, and I don't think would work, was, and I'll read exactly what I've seen some of this communication between constituents and our state attorney's office. The state attorney's office advised that you could sue for civil trespass, claiming that someone went onto your property and interfered with your use and enjoyment of that property. However, federal law regarding airspaces and aircraft cannot get so close that it is in the immediate reach of the airspace next to the land. No courts in Maryland have interpreted what that means yet. And then in addition, there's no legal guidance to decide how close is too close. You could sue for civil nuisance, claiming acts of another, trying to interfere with your use of the property as to deprive you of the use and enjoyment of it. However, you'd likely need to show repeated acts, and you'd also have to show a significant interference.
Thank you.
Thank you, Mr. Chair. I was actually thinking the exact same thing, and I actually have Delegate Valentine's bill up in front of me. Let me just run this by you. If we pass Valentine's bill, well, I understand. If it goes into law, you can't do two things: conduct visual surveillance of an area of another's residence where the other has a reasonable expectation of privacy, or maliciously engage in a course of conduct that alarms or seriously annoys the other. And it seems that those two infractions are what your bill gets at. So if we pass his bill, which prevents the recording, it also prevents the intimidation and harassment, couldn't this crime be charged under his bill?
So what you're saying, doesn't even need to be changed.
Well, what I'm saying is you're bringing two concerns, the surveillance and the harassment. The harassment's already there in current law, and his bill adds the surveillance. So just to think this through academically, if we pass his bill, are you made whole? Sounds like a question we should all think about. Thank you, Mr. Chair.
Delegate Phillips, your last question. Oh, Conway has a question. Your next to last question.
So one of the things that you don't address in this bill, you talk about federal law. What if it's state? We've got this whole thing going on now about observation of facilities to do property taxes. We've got other related things that are going to take place, right, where the state may want to do this. So that would be one thing that I'd ask you if you'd be amenable to adjust. And the other is, I think with Valentine's bill, we don't necessarily talk about videographic and photographic images in that bill and taking those images. And I think you addressed that in your bill.
Yes, so that did get brought up leading up to this, especially with all the lengthy debate we had on the floor with SSTAT and everything that they're doing. And then in addition, obviously, there's been a lot of bills through our committee or discussion with law enforcement using these, using drones and technology to pick up images from up in the sky. I don't think, I mean, I guess an argument can be made, but I don't think that whether it's SSTAT or whether it's law enforcement, they're intentionally intimidating or harassing another person. So I think that in that case, they wouldn't check that box.
Delegate Conaway for the last question. You're good, okay. That, I believe, concludes the testimony for House Bill 1349 and concludes the bill hearings for today. Committee, we are voting at 3 o'clock in 9 minutes. We need to give staff an opportunity to do what they need to do, so stay out of their way. We'll be back at 3. Thank you.